We'll call this meeting of the Town of Clayton Board of Adjustment to order. On our agenda, item number 2, adjustments to the agenda. Madam Clerk, I think we do have one. Is that correct?
I'm going to ask that you ask full business discussion of the proposed rules of procedure.
Okay. Duly noted. Okay, moving down to approval of minutes, item number 3. I trust everyone's had a chance to review the minutes. Any comments, corrections? Hearing none. Got a motion by Mr. Perricone,
Second.
second by Mr. Casey. All those in favor say aye. Aye. Those opposed? Motion carries. Item 4 is a public hearing, an evidentiary hearing. Item 2021-56, VAR O'Neill Overlook Variance. At this time, I will open the hearing and ask for anyone who wishes to speak to be sworn in by our clerk.
Anybody that wishes to offer testimony, please rise and raise your right hand. Do you solemnly affirm the testimony you're about to give is true to the best of your knowledge and belief? Thank you. When you go to offer your testimony, you can repeat that with sheet.
It's hard to hear the air. If you would tell me which item this is.
This is, do we, what's coming up first?
This is the first item, number 4, 2021-56, VAR O'Neill Overlook Variance. Okay, we'll now call on staff for the presentation.
Good evening, board members. Ben Painter, Town of Clayton Planning Department, going to present to you the O'Neill Overlook Variance Case 2021-56 VAR. This request is to permit the building of a second access road and additional housing units in a resource conservation area. The existing use of this property is vacant. The location is to the north of the existing Rollingwood Subdivision neighborhood. To the north, O'Neill Street is abutting this property. And property is 15.55 acres. So this property has an approved subdivision plan. It was approved by council May 3rd, 2021 with conditions. Before that, it received TRC certification in April. Just to mention, the RCA area stands for a Resource Conservation Area. It's in our UDC to prohibit building in environmentally sensitive areas such as steep slopes, stream buffers, floodplains. Yeah, those are the main ones. Joshua Baird will also come up following my presentation to go into more detail on the RCA and the requirements in the code as well. So on this subdivision, there's a total of 37 lots that were approved on the plan. There's also 2 access points, one coming off of O'Neill to the north, and then another access point going into the existing Rollingwood subdivision. Sorry?
Just point those out. Access.
Oh, yes. Yeah, so you see the one to the north coming in from the northwest, and then the second access point is coming in off of Oakdale Avenue, going into the subdivision from the south. The property contains RCA areas and other portions of the site, particularly to the north. in the northeast, but the variance request is only for the portion to the south on the bottom. And I think Joshua has zoom in on that site in his presentation to go over that specific area. Additionally, the UDC requires a second access point for any subdivision greater than 30 lots. So in order to achieve this approved subdivision plan, a second access is required, which goes through the SCA area. Here's the view of the property from the street. You can see Oakdale Avenue. And to the right of Oakdale Avenue on this picture, it's a vacant area. That's where the second access would come through. There are subdivided lots from original Rollingwood subdivision, but they're undeveloped at this point. And then to the left of the street, there are existing houses. So the applicant has addressed findings of fact. That's been included in the packet. They'll go into that into greater detail as well. This subdivision plan was approved by council with conditions primarily to address environmental impact and to minimize those concerns. And the applicant has also submitted for permits to the appropriate agencies, environmental agencies that would have jurisdiction over the RCA areas. And with that, I'll turn it over to Joshua Baird, town engineer.
Good evening, Board. Chair Joshua Baird, Engineering Director. I want to take a step back and just kind of dive into the code a little bit further and talk further about the resource conservation areas. Per the code, these areas that are to be set aside and platted are anything that is in a 100-year floodplain. Stream buffer areas, this is a specific wording from the code, slopes that are above 25%, that's the slope, the grade, that are of at least 5,000 square feet and contiguous together. And then any jurisdictional wetlands that are considered under federal law and per the United States Army Corps of Engineers to be a jurisdictional wetland. So any of those areas per the code are to be in resource conservation area. Within those areas, the prohibited uses that are currently called out in the code would be stormwater control measures, roads, parking lots, impervious surfaces, except as specifically authorized. I want to dive into this one a little bit more, just how staff have been currently utilizing and interpreting that code is if it's a road that is crossing a stream, again, one of those jurisdictional or wetland, and the applicant goes through the proper channels to receive those permits and get those impacts approved by either the state and or the Army Corps of Engineers, we are assuming that to be specifically authorized. And so that's something that we've been working through as far as the roads go. So any type of road, if it's going to be something that's related to access, if they get the proper permits, and that's outside of the town's jurisdiction, we don't have the jurisdiction over the streams, any impacts to the stream, that's other agencies, those have been able to move forward through that area, through that resource conservation area. Additionally, golf courses, ag, or forestry activities that are not conducted according to the accepted best management practices. So that's currently from the code, 155.500 if I recall off the top of my head here. Intent of the resource conservation area, really it's diving into protecting those natural resources. You know, a lot of these areas are likely around the water resources, again, those streams, those floodplains, those jurisdictional wetlands. And so the intent of it is really to preserve that environment, protect those natural resources. It does add to some visual and kind of aesthetic qualities as you do have some preserved areas in and around town. It does encourage site design techniques that really work around that and preserve the natural environment and really enhancing an urban setting, a developing environment. Additionally, when you have these slopes, control really erosion, slippage, and sediment runoff that may be into these water resources, the streams and our waterways. And then also there's wildlife and habitat aspect to it too. When you have these connected areas in an urban environment, Some would say that there are habitat corridors for migration, and when you have certain areas in a built environment, an urban environment, where wildlife and habitat can migrate through different areas. So just kind of general, what I think the intent of the resource conservation area was. Looking at the site, let me do something different here. Looking at the site specifically, this is a blown-up version of what the applicant is requesting a variance from. As you can see, the area in blue here, an exhibit put together by the applicant, is what would be a resource conservation area. That is areas that are of that 25% slope or greater. You can see here that they do have an access road coming out that would be crossing that. And then additionally, they are proposing homes and impervious surfaces in portions of that area. So kind of two things here, I guess, that the variance is requesting variance from would be the road crossing that, and then also just the impervious surfaces. Those two items are kind of called out there as prohibited in the resource conservation area. Let's see. While I'm on this slide, I will say, the applicant has been in contact with the Army Corps of Engineers, the contacts there, and they do have approval. There is a stream through a certain portion of this. They have received approval for impacts to that, and I will let them speak to that further. But they have gone through channels to get the proper approvals to actually fill in these areas, and now it's just a variance from our code. I will talk briefly on drainage. In this, let's see if this works. From a drainage pattern standpoint, this is Oakdale Avenue here, currently a town maintained road. Town does have some infrastructure that does have a culvert that comes under Oakdale here. Current drainage pattern is through this draw, through this corridor. Again, that's a lot of times where we get the steep slopes, and then it continues to go on out where it's released outside the project and continues on downstream in this area. So this is kind of the current drainage pattern. The applicant is proposing to pick up that culvert, pick up that flow, route it around along the right-of-way, and then discharge it here. So it will be discharging to the same location, basically bypassing some of that current environment and current draw. Also need to note, and I think this is kind of just the best picture I could come up with, just some of the existing contours. And again, you can really see some of that topo and where those 25% slopes are. If you notice and you're looking at it, some of that steepness does abut and get close to Oakdale Avenue, which is a town road and town infrastructure. I do need to note that there is certain areas along Oakdale that we are actively monitoring from an infrastructure standpoint. This particular area, there is some erosion, there is some instability in this region, and so it is an area that we are monitoring. No current jeopardizing of the infrastructure, but we are something that if a problem may come up in the future, I can't speak that it will or will not, but we are monitoring a certain area in here just to ensure, due to the instability, that it does not continue upstream and jeopardize our road. So we do have an area in here that we have been monitoring for probably about a year and some change now that is in this location that would be actively filled in if the variance request is approved tonight. I noted earlier, the applicant has gone through and received permits from the Corps, and I did have this slide in there that does show where the stream is in green there, and the area that they have submitted for permits for to fill as part of getting those agency approvals. And with that, I guess Ben and I could take any questions before we turn it back over.
Any questions for staff?
I have one.
Yes, Speaker.
Have there been any issues prior to this with the subdivision ruling what is that exists today as a result of this area?
I'm sorry, I didn't quite hear the whole question. I'm sorry.
Have there been any issues in Rollingwood prior to this with regard to the conservation area? Have they had any issues, any drainage runoff prior?
I mean, I've been with the town 2 years coming up this fall. Other than some of the instability that is on the project site, I'm not aware of any drainage concerns. There may be some out there, I just may not be aware of them. But within the existing subdivision, I'm not aware of any. That's not to say there haven't been any, but just in my time, I'm not aware.
And just to clarify, you said the stream right now is going through the culvert underneath the road, and their applicant wants to extend that culvert?
So the applicant, my understanding, and I want to be sure the applicant has an opportunity to clarify if I misinterpret anything, but based on my understanding of the project, the culvert is, and actually it's called out here in the bottom, hopefully you guys can see that, existing storm pipe that does come under Oakdale. It is released right here into that drainage way. If I understand the project correctly, the start point of that what is stream, this would be kind of the headworks of that stream is here. And from this point down to where they would be discharging it would be the area that they are seeking from the Corps and other agencies approval to fill in. Hope that answers your question there. If not, I can certainly.
Go ahead.
Just a couple questions. The lots 63 or 62 through 60 or 60 through 63, excuse me, of the previous subdivision, the original plan, flat plan. Do you know what the status or what they were approved to be built for originally? You have to go back to the track map assembly.
Is it this one here, or which one's lot? I'm not sure I follow which lot.
So these lots at the bottom corner, the 4 in the assemblage, you see those in the yellow?
Along the rear here?
Yes. Those are part of the original plot plan for the original subdivision. Do you know what the approval of those, what was approved to be built on those?
I do not know off the top of my head. I don't know from a zoning standpoint if Ben has the answer to that.
Because of the age of that subdivision, I haven't seen the plot plan for that, so I couldn't speak to it, if they were buildable or not. We could probably pull a plat and see if there's any notes on that, but I hadn't seen it.
Okay. And then the second question I had was just a point of clarification. You had mentioned that the town doesn't necessarily have ultimate authority over whether or not the road could be built. Is that correct?
The impacts, excuse me, the impacts to, so that stream is jurisdictional feature per the Corps of Engineers and the state. We do not have jurisdiction over that. That would have to be approved by the state and the Corps. So we do not have jurisdiction over the stream itself, the actual waters.
But that affects, obviously, the home construction and the street, right? Those particular, if you look at the plot plan, this one, so these lots here within the area, I guess 12, 13, 14, 16, I guess 12 through 18, it affects them as well, correct? These 7?
That's correct. So to be able to build at least the 13, 14, 15, 17, it is dependent upon receiving that approval from the Corps of Engineers in the state. And I believe, and I'll let the applicant confirm, but I believe they have received that approval from the proper agencies.
Okay, and the entire request is for 37 home sites, right?
Is it 37?
37.
Okay, got it.
I've got a couple questions, maybe for Ben. As far as, and I think I know the answer to this, but just for the record, the subdivision plan has been approved by the town as far as a preliminary approval?
Yeah, there's been preliminary approval of this subdivision.
And what we are seeing now, that is, there's been no changes to that approved plan as far as the location of the lots in the street as it was originally approved?
Correct.
Okay. And then Josh, on the, I know you gave a little, I guess, a staff policy of how you have been looking at road crossings and things like that. So just so I'm clear, what's different about this, I guess, is that we are platting lots and as well as a road. If this were just a road, I guess, impacting, encroaching, it would fall under staff's policy, but we are platting lots in the RCA, which makes it different, and that's why we're probably here tonight, right?
Yeah. So that's the difference. Assuming the applicant can get the proper approvals from those agencies, we have been proceeding with that. Again, getting back to the way the code is specifically written, is that it's those roads are prohibited except as specifically authorized. We take that to believe it's specifically authorized by the other agencies that allow that disruption of the water resource itself, that jurisdictional feature.
And do we know, was the RCA shown on the preliminary plan when it was approved?
Yes, I believe they were.
Okay. Okay. Further questions for staff? Thank you. We'll now call on the applicant, and if you would come forward and state your name and address for the record.
All right. Good evening, board, staff, audience. My name is Emily Bedingfield. I am 328 East Main Street. I'm representing the applicant this evening. I'm also providing expert testimony from my background as a urban and city planner. I have a master's degree in urban and regional planning, certification through the American Institute of Certified Planners, and over 10 years of experience in both the private and public development sectors. So I'll be providing some testimony from that expertise and background as well.
Mr. Chairman, may I just make the comment concerning representation of party appearing?
Go right ahead. I apologize.
I'm required by the State Bar to make this comment to you. There is a formal ethics opinion put out by the State Bar, Ms. Bedingfield, concerning appearing in a representative capacity before a local quasi-judicial board in a quasi-judicial hearing. The board has given the opinion that that represents a practice of law. One of the ways we try to avoid a conflict with that is, one, to point that out to you and to ask if you would agree and acknowledge that when you appear tonight, you're not appearing to represent an applicant, you are not appearing to make arguments or to examine witnesses or to summarize a case or to otherwise do the kinds of things that lawyers would do in bringing a case like this forward. You're appearing only as a fact witness in this case, as a witness to give testimony and perhaps offer exhibits, but not in a representative capacity. If you would agree to that and acknowledge that for the record, I think we'll get around that
I do agree to
procedural
that.
problem.
And thank you for the clarification on the terminology. A little bit of what I have in my presentation is going to repeat some of what staff said, so I'll move quickly through that. Of course, the variance request is associated with the O'Neill Overlook subdivision. That preliminary plat was approved by the Town Council on May 3rd, 2021, project number 2020-75-SD. Just wanted to give a quick picture of sort of where we are in the world. The bright yellow star on the screen is the general location of the O'Neill Overlook subdivision. Of course, we're just outside of downtown on North O'Neill Street on the southeast side of the street, and directly north of the existing Rollingwood subdivision. The layout on the screen is the preliminary plat as approved by the Town Council on May 3rd. There are 37 lots. There are 2 entrances, the primary entrance being off of North O'Neill Street and the secondary entrance being off of Oakdale Avenue, which provides secondary access also for the Rollingwood subdivision, as Oakdale Avenue is, of course, one of the roads within the Rollingwood subdivision. All of those sort of dashed diagonal blue areas on the map are resource conservation areas. And I want to point that out because you can see that this site has a lot of them. We're pretty well hemmed in to the north and the east and even to the south. And the vast majority of the resource conservation areas on site are preserved. And you can see the green area is open space that will not be developed, and the dark blue is the stormwater feature that was included with that preliminary plat. That sort of, that dashed line on the south towards the second entrance onto Oakdale is, of course, the resource conservation area that we're discussing this evening for your approval. So I want to talk about that secondary access road. It is the road that is driving these impacts, and the impacts are, of course, the reason for the variance request this evening. As I mentioned, it connects directly into the existing Rollingwood subdivision and the existing street system within that neighborhood. The secondary access road, as staff mentioned, is required by both the Unified Development Code and the Fire Code Appendix D. Primary reason being because anything over 30 single-family lots requires a second access point. Of course, with 37 lots, the project wouldn't be viable without a second access point. Another reason is your road length is limited with lots of these size to 750 feet. When you're constrained by the environmental features like we were on this site, your road gets pretty long pretty quickly, and having that second access point allowed us to utilize the most logical portions of the site for development. Another item to point out is the location of the road. Had we put it anywhere else on this site, to the north, to the east, somewhere else, it would have resulted in greater environmental impacts than we're seeing here. Part of the benefit of this particular location is that we're actually minimizing impact compared to other selections that could have been chosen to meet the requirements of the Unified Development Code and the Fire Code. I also want to point out a secondary benefit that we were proud to be a part of, and something we were very proud of to talk about to the town council, is we're, like I said, providing that secondary access point to the Rollingwood subdivision. Rollingwood currently has about 114 single-family homes with one entrance. As I mentioned earlier, the town of Clayton and the Fire Code require a second entrance after 30 lots. Now, Rollingwood's fine, they're grandfathered in, they don't need to go in and add them, with older neighborhoods, as you all are aware, but by adding the second access point, we are enhancing the public safety by way of providing additional emergency access to the Rollingwood neighborhood, just adding to the reasons why this was a great location for us. And we are able to put it on existing property that was vacant within the Rollingwood subdivision. My professional opinion would be that that property has not been developed because of the resource conservation and the obstacles that that provides. It being so close to the road, there really wasn't room to put in many homes in that area. The access road in that location obviously requires impacts to the stream, as Joshua explained, and to these steep slopes that are associated with the stream and with that stormwater runoff that's in that area. Those steep slopes do meet the definition of resource conservation area, which is why we're here before you this evening. And the stream, we have received, as Joshua said, approval from the Corps of Engineers for that impact. And our environmental consultant will be speaking to that in just a minute. So just to rehash the request, 155-100 restricts impacts to resource conservation areas. Slopes above 25% of at least 5,000 square feet of a contiguous area are RCAs. And we are requesting a variance to allow impacts to 12,515 square feet of steep slopes. You've already seen this because Josh had it pulled up, but this is just a zoom in of the exact extent of the impacts. This has been well designed, and our stormwater engineer will speak in just a minute as to the design. But again, it'll be a 12,515 square feet, and this is a direct correlation to the approval and the design associated with the approval that we received from the Army Corps of Engineers. So I'm going to hand this over to Jennifer Burdett, our stormwater, who is our natural resource consultant, and our stormwater engineer will speak in a minute, and then I'll step back up to speak a little bit to the findings. So I'll ask Jennifer to come up.
Good evening. My name is Jennifer Burdette. I reside at 10212 Creedmoor Road in Raleigh. I'm the owner of Natural Resource Consultants, and I put together the permit application and obtained the nationwide permit and water quality certification for the project. I'm going to flip real quick just because very instructive. This is, we mentioned the pipe coming under Oakdale Road. You can see it up in the top right corner here. This is facing Oakdale Road. So that pipe is stormwater that's coming from the Rollingwood Subdivision, and it discharges at the top of that very steep slope. And you can see there, and there's just another, this is scooched this way, that it is really causing a whole lot of erosion on that steep slope. Anytime you're releasing stormwater at the top of a slope has the potential for a great amount of erosion. So that's the existing condition there. The stream channel, that stormwater that's discharging there, but the stream channel starts somewhat lower that you saw on the map that showed you the permit application. It starts a little lower down the valley. This is a source of sedimentation, stream sediment to the stream channel that is a water quality issue. Our design, I'll go back to my notes. So with the road, they are proposing to fill from the top of that for where that stormwater, or that basically ravine, from the top of it down to the point at the last lot that you have on your plan. What we did was ask for that stormwater to be routed and discharged at the stream level as opposed to high up on the steep slope. And be sure to put in a riprap pad there to dissipate that energy so that stormwater is released in a less erosive manner downstream. And it obviously has the benefit of stopping that great amount of sediment that's being released from the head cut and the incision of the channel upstream. We have that approved by the Army Corps of Engineers. We've submitted a permit application and received a nationwide permit for the entire length you saw on, I think, Josh's and Emily's presentation. And the water quality certification was approved without any written approval because it fell below the threshold. So we have both our Corps of Engineers nationwide permit and our water quality certification for the project. And I will turn it back to Emily or Eva.
Jennifer, could you just give us your credentials for the record?
I'm sorry, I totally forgot that.
That's fine, that's fine.
Sorry, I'm the owner of Natural Resource Consultants. I've been a consultant for 29 years here. I have a professional wetland certification and professional wetland scientist certification and a bachelor's in biology and a master's in soil science.
Thank you.
Thanks.
Good evening. My name is Eva King. I'm a professional engineer with Adams & Hutch. We were working on the preliminary plat for this project and are getting ready to submit construction drawings for this one. I'm going to try to keep this short to not repeat things that have already been said. But I know, as Jennifer mentioned, one of the big concerns for this one was the stormwater being discharged through the pipe underneath Oakdale Avenue. There's roughly about 2.5 acres of area being discharged in this pipe. If you take a look at the grading for this site, there's a good amount of overland flow that also ends up in the stream that goes through existing properties before it leaves the site and comes back onto the O'Neill Overlook project site. I know there is concern by adjacent neighbors to see if our project makes things worse and if there is more water being into it. And even though we're improving the immediate problem right behind Oakdale Avenue, the question is if there's going to be more flow dumped onto the stream further down. The answer to this question is no, we're actually reducing the area of water that is discharged by a good 25%. By keeping the water that our project is generating on our side. If you take a look at the grading plan, you can see that we are pulling the stormwater pipe all the way down to where the existing stream is located and then routing it to the upper right corner on the stream into a stormwater measure where we have a chance to reduce the flow, discharge it onto a dissipator pad and going into the existing stream. So the amount of area that is currently draining into the stream and going through the adjacent properties on the bottom right corner of the stream is being reduced, and therefore, along with fixing the erosion control and the stream problem that Jennifer presented, the flow will be reduced further downstream. And I think Joshua mentioned this, and that is about the extent of what's related to this area.
Okay. Thank you.
Thank you.
Hi, Emily Bedingfield again. So I wanted to briefly address the findings of fact. Of course, we did provide written responses as part of our application, and those are submitted into the record as part of that application, but I did want to address them verbally as well. Jennifer, of course, was able to address the environmental benefits. One thing we looked very closely at was whether or not what we're going to do was going to adversely impact the ecology of this area. Of course, it's a resource conservation area, so that's something we needed to look very closely at. And the severe erosion that was out there and the resulting sedimentation, as Jennifer explained, was something that we were able to solve and not just reroute. And we were happy to do so. And then the stormwater concern, you saw it in your packets. At our neighborhood meeting, we did hear concerns from neighbors about adding to the existing stormwater. And as Eva testified, we are actually reducing the stormwater to the properties to the east in that stream by 25%. I can't speak as to whether there is a current actual stormwater issue on those properties, but there is at least a perception of such. So first finding number one is that unnecessary hardship would result from the strict application of the ordinance. For all of those reasons and for the reasons that I explained as far as locating that road where we did, we could not put a secondary access to this project without impacting resource conservation areas. As I showed you in the map, almost the whole project is surrounded by resource conservation areas, and what we did was we chose the area that was going to have the least impact. And strict application of the ordinance would have meant that our project was not viable in the form that we were working towards. Finding number two, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Of course, everything we're talking about this evening is topography. This is unique not only because of the topography in and of itself, but because of the highly erosive quality of this particular topography and the stormwater pipe that's coming into it and just creating all of that erosion and all of that sedimentation and starting to eat away, like Joshua said, getting closer to the road. Actually, we were out on property taking a look at the site, and as we got down in there, we saw underneath the tree where it was getting very close to Oakdale Avenue, and we were the ones who called that in just to make sure that they were able to keep an eye on it in case it got worse. So also the location of that particular RCA so close to the road and parallel to the road meant we had to cross it in order to do the, put the road in, and the necessary impacts are the degree that we showed on our impact map. Finding number 3, the hardship did not result from actions taken by the applicant or the property owner. This is a pretty easy one. It's a natural feature. The stream there's a stormwater pipe that's adding to that natural water flow. So this is absolutely not something that was caused by the applicant or the property owner. And finding number 4, the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice achieved. So the environmental and the engineering justifications that we provided this evening are evidence of the benefits of this project to the public health, safety, and welfare. The vast majority of RCAs on site are preserved. As I mentioned, we've minimized our impacts. The proposed impacts will not threaten nearby properties. Rather, due to the degraded condition of the channel, the result provides improvements to the existing erosion concerns in the right-of-way and reduces the risk of downstream erosion. Additionally, we are actually expecting environmental improvements by reducing the sedimentation as we spoke about earlier this evening. So we are happy to answer any questions, myself, Eva, or Jennifer, or our staff. And thank you very much for your time this evening and for your consideration of our request.
Okay, questions for the applicant?
So did you say the Army Corps of Engineers did approve the permit?
They did.
Okay.
Emily, as far as the stormwater piping that Eva just spoke about, has that been reviewed and approved by the town, the actual storm drainage?
So our construction drawings have not been submitted yet. Preliminary engineering was submitted as part of the preliminary plat and was reviewed at that time. If this variance is granted, we would move forward with construction drawings using the design that Eva showed.
Thank you.
And one of the conditions of approval on this is that the overall design is subject to approval of by the engineering department and by the town of Clayton.
Okay.
So they would have final review over it. Mm-hmm.
Jennifer, I have one question. Near the end of your statement, you had just mentioned that, I'm not sure if it's you and Joshua, you at this time do not know of any flood issues on the existing property where the watershed is going to be imparted in. Should we know definitively if there is a problem there now, and if we need something that the Army Corps of Engineers would suggest that might be more fitting to for the development of that particular parcel? Not knowing if there's an issue now, I would hate for us to find out there was an issue because we just didn't look any further. Does that make sense?
I'm not sure. That might be a Joshua question in terms of regulatory authority and review. I don't know that the Army Corps of Engineer has any jurisdiction over any part of this other than that stream. Mm-hmm. The rest of the design will go through the channels for review by the town through the construction drawing review, and will be balanced against all of the, applicable ordinances and regulations as far as the grading and erosion control and all of that.
Yeah, so my only concern is that when you're finishing off that, we don't know if there's any flood issues now. I think we should know if there's any issues as we go forward with the project. Joshua, if you have any insight on that.
Yeah, I can try to, I guess, shed some light on that. In the existing subdivision, again, I'm not aware of any. That doesn't mean there has not been any complaints to the town, south of Oakdale in that existing subdivision. That's not to say there has not been. Again, I do have limited time here, and also there are additional staff that do respond to any complaints that may have been taken care of, resolved, and not even made it to my level that I was aware of. So again, I don't know that. To my knowledge, I don't know that we haven't got to the CD process, the construction drawing process, where we really look at all the hydraulics and the sizing of that pipe. To my knowledge at this time, I really can't say that the culvert under Oakdale, if it's undersized, oversized, it's able to convey. As proposed, they're not looking to change the drainage pattern south of Oakdale. It's just in their project site north of Oakdale, looking to just reroute that around. And then as Emily alluded to, once we get into the construction drawing process, there would be a thorough review of the sizing of all that pipe to ensure that it's not going to back up as they're extending it, to ensure that that pipe is appropriately sized such that it does not cause an issue back when they connect to it and extend it, any losses or anything that have been with that additional pipe. Does that answer your question at all?
Yes.
Or shed some light there?
Yes.
Anything you want to add?
No, that was great. Thank you.
Thanks, Joshua.
I got a question. So just to kind of, I'm just trying to get some things here in my head. So that is considered a wetlands, correct, that area?
That would be something I would want Jennifer to give the exact clarification on.
Hi, Jennifer Burdette again. So it's a stream channel, which is the waters of the U.S., and both streams and wetlands are considered waters of the U.S., but it is stream and no wetland areas.
So, again, I'm just an old country boy from Detroit, so if you can get me up to, so what is it as far as building near those areas?
I'm sorry, one more time, please?
What's the code, the rules as far as building near those areas there?
Yes, so any impact to waters of the U.S. that would include either streams or wetlands requires a permit from the Army Corps of Engineers, subject to the Clean Water Act. And that permitting process asks applicants to review the entire project, and it goes through a review that you have avoided and minimized to the maximum extent practicable. And so they looked at that the necessity for the road and the connection to Oakdale Avenue, and then also that condition of the existing the very deeply incised stream and eroding banks, and determined that it met the criteria for issuing a permit, a Clean Water Act permit.
Is there a criteria for how close you can build to it?
So this area is not subject to the Neuse River riparian buffer rules. The stream channel, so it's two separate layers. There's the waters of the U.S. that the Corps of Engineers implements. Then there is the Neuse River riparian buffer rules that are implemented by the state, and they're totally separate. The state decided that the stream channel was only subject to the buffers much lower down the valley. I forget exactly where it was, but it's like 2 or 3 lots to the east, thank you, to the east where the riparian buffer starts. And the riparian buffer does prohibit you from building within 50 feet of the stream channel, but this section of stream channel, the Division of Water Resources decided it did not meet their criteria for requiring a buffer.
Okay.
If you would entertain me for a moment, so I understood that you already have approval from Army Corps Engineers and you cited the permit. Are there any other permits that you're seeking or need to seek to build on this lot as related to its environmental status?
As far as the waters of the U.S., there's the nationwide permit by the Corps of Engineers. That permit isn't valid unless the state issues what's called a water quality certification. And they have issued general certifications that spell out if your impacts are below certain quantities and other sort of laundry list items that your project meets. And if you meet those, then you do not have to get written approval from the Division of Water Resources. The permit is there for you to use as long as you meet that threshold. And this project fell below the written approval threshold.
So do you need an NCDQ permit at all for this?
We actually have one. That general certification is a blanket issuance, and it certifies, it provides the water quality certification. We just didn't have to, and we submitted a courtesy copy to the Division of Water Resources. They received it. They just didn't have to write us a letter and say, yes, you can.
Thank you, and I apologize for asking the question in two different ways, but the other thing I wanted to ask quickly is you mentioned that you had, and I saw on the screen, the stormwater management, basically, that's the wrong terminology, your stormwater design to handle it once the subdivision is installed. And you mentioned very briefly about which way the water flows in accordance to that design. And I think it's worth just reviewing for a second. At the intersection, and I forget what street it is, so forgive me, but the intersection of, I think it's Oakdale Avenue, correct? And Street C. At this intersection, where does the water flow that hits the street in the hardscape areas from that point flow to?
The water in the street flows into the pipe system. Can you see that? Because this is the low point of the road. So the water enters it here, the stormwater pipes back the grade. So stormwater pipes go down while the grade goes up. These pipes are rather deep. I don't know if you can see the mouse, I can.
Okay.
But
And
it goes into the stormwater system right
Okay,
here, into the stormwater pond.
So is that where you're arriving at your 25% reduction in?
No, the 25% reduction that I calculated is, you see the 4 lots on the bottom of the screen? Those are existing properties.
Correct.
And the stream that we're impacting goes through those lots, and right behind the 4th lot, it kind of enters, it leaves their backyard and goes back onto our property. And that's the point I used for my 25% analyzing.
I see on the contours, you got a breakover right there, so it's flowing. 25% of it's flowing in the opposite direction it used to, essentially. Is that what you're saying?
25% is being captured by our stormwater system, then goes into the pond. So upstream, a little on the right, those two streams kind of meet again and meander bounce. So at that point, the water all gets reunited. But for the short period of time, yes, it's being rerouted towards the north.
Okay, thank you.
You're welcome.
Any further questions for the applicant?
This Street C, is it going to have curb and gutter?
Yes.
Okay.
Everybody good? Thank you. All right, is there anyone wishing to speak in favor of this variance requested? Anyone in opposition that would like to speak? Okay. We'll bring this back to the board for discussion. And hearing nothing, we will, as far as the hearing goes, we will close the hearing, Mr. Attorney, and bring this to the board for our discussion. If the board agrees, we would, I'd like to take the findings of fact one by one, as we have done in the past, and please chime in with your thoughts and discussion, but any issues with that, we'll just start with finding one. Finding fact number one, unnecessary hardship would result from the strict application of the ordinance. It shall not be necessary to demonstrate that. In absence of the variance, no reasonable use can be made of the property. Thoughts, comments? I think looking at the staff commentary, I totally understand the environmental constraints given at this point to make the subdivision to be able to meet the town standards for the second access. There is a environmental constraint. It appears that there's only that one area to actually make that connection to provide that second access, and this is in that environmental area that we're discussing now. So just my comment.
I hear what you're saying. I think that there's two considerations here. Obviously, the fire department one is a consideration, but the ordinance actually reads 30 subdivisions or less, and if we're making a variance based on these lots that were absorbed into this new subdivision, it would be a 30 lot subdivision. So, I question as to what, it's not to us to determine the economics of whether a 30 lot subdivision is viable or not, but really what this variance specifically addresses are the 4 lots themselves. Now, the 4 lots, when then added to the subdivision, we're at 37. Now we're reaching a threshold that it would require the second access. So really the variance is limited to those 4 lots and not the entire discussion. Does that make sense?
I think my opinion, Tom, on that one is that I'm looking at the subdivision as a whole,
right,
as it was submitted to the town and received the preliminary approval. And I think one reason I asked the question of staff, had there been any changes from what was submitted? Obviously, this was submitted, more than one lot, more than, the 4 lots here plus the large lot. But a preliminary plan was submitted for the entirety. So I'm looking at it as the total number of lots.
That's true, and I think that maybe it's just an academic point. If we take those 4 parcels by themselves, I think that the restriction does make them unbuildable. So even if we bifurcate this issue into the 4 lots and the rest of the subdivision, I think that's the same result, and that's why I'm pursuing this line of logic.
I understand. Any further discussion on finding number 1? All right, let's move to finding fact number 2. The hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. Discussion on finding fact number 2.
Just a comment, I think it's clear, it meets the criteria in terms of peculiar to the property, topography. Thought I was, but I'll get closer.
Further comments or discussion on finding number 2? All right, moving to finding fact number 3, the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge of circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship.
Again, I'd comment that it's just the opposite, that the actions of the applicant are likely to mitigate a problem that's occurring and impacting an existing subdivision that over time appears like it may get worse and create issues there, so.
Any other comments on finding of fact number 3? All right, moving to finding of fact number 4, the requested variances are consistent with the spirit, purpose, and intent of the ordinance such that public safety is secured and substantial justice is achieved.
Again, I'll comment, the proposed actions of the applicant are likely to increase safety, particularly if erosion is continued along Oakdale Avenue, which may negatively impact that road. In addition, the second access to that subdivision that was not historically required would be provided. So there's improvement in public safety for the residents of that subdivision.
And I think one thing that stands out in my mind is staff's testimony that they are actively monitoring Oakdale for erosion problems. This actually, I think, is very unique in that this can actually help, if approved, help the storm drainage system erosion problem that is currently being experienced out there, which I think is extremely unique. But in this case, I think it's not what you would expect, but something like this could actually mitigate an existing problem. And so I think that does play into the public safety, because that testimony about our town engineer, they're already currently monitoring the erosion effects to Oakdale, stands out in my mind. Any other comments on item 4? All right, any other discussion on the matter before we ask for a motion? All right, hearing none, I'll assume we're ready to vote. I'll entertain a motion.
Should the motion contain the recommendations?
I think so. I think that'd be appropriate.
I'll make the motion to approve this motion based on the following findings. Unnecessary hardship does result from the strict application of the ordinance. The hardship results from conditions that are peculiar to the property, such as location, size, or topography. The hardship did result from actions taken by the applicant or the property owner. The requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. And I add the following conditions. That resource conservation area impacts are limited to the extent demonstrated in the approved design. No impact shall take place until the town of Clayton has approved soil and erosion control plans, and final design is subject to review by the town of Clayton Engineering Department.
Okay, we have a motion by Mr. Perricone. I hear a second.
Second.
Mr. Sims. Second by Mr. Sims. All in favor of the motion, say aye.
Aye.
All opposed, like sign. Motion carries. Okay, moving along now to item number 5. Item number 5 under old business, item A, 2021-40 VAR Crawford Cookshop parking variance. This would be to review the findings and conclusions for the Crawford Cookhouse variance case. And I will call on staff at this point.
May I ask one question? Is this a time that there will be comments available, or is it simply you all can review and then either pass and then or otherwise?
Yes, sir. Raz, would you like to answer?
If I may respond, Mr. Tu, you may be aware this board was just constituted about a month and a half ago, and we're getting our procedures straightened out. In the case that was heard last Monday, formal findings and conclusions, findings of fact, have traditionally just been the 4 statutory, I call them conclusions of law, but the requirements for the findings in order for a variance to be granted. We had been looking into the proper procedures for this BOA. I suggested that the board may want to consider, I suggested to staff that the board may want to consider findings of fact supportive of the 4 statutory conclusions. That was done within the last couple of days. I submitted a draft to staff 2 days ago. Yesterday, findings were prepared. We have findings, and I apologize they haven't been made available more frequently. They are about a page and a half long. There's nothing profound there. But this is the deliberation phase. Of course, it's in the council's discretion to determine if they would like to allow for comments, but the public hearing, of course, has been concluded in the case. I would suggest that if there are any comments received, or if there's any discussion with Mr. Tu or others interested in the case, that it be related simply to the findings and not to evidence related to this particular variance request.
Okay.
So, again, just brief answer, yes or no?
If it's the chair's decision, I think the answer is yes.
Hard for me to hear and hear from most of you, and I apologize for that. But with this on, you really need to speak into the microphone. So I understood some of what you said, but essentially the question is whether or not the purpose here for the board is simply to review this themselves or to take any comments relating to this.
I think based on what I've heard our attorney say, Mr. Tu, if you had comments related to the findings, I think you could address the board.
You think that it will be permissible?
Yes, sir.
Okay, thank you.
Mr. Tu, did you want to address the board tonight, or?
Yes, I do.
Okay, I think it'd be appropriate at this time.
My name is Alan Tu. Thank you for the opportunity to speak. I have been here for the proceedings, and I've read these findings of fact and understand that in order to ultimately have this as a valid act, they're findings of fact, which must be supported by some evidence, and then the conclusions of law need to be supported by the findings of fact. And then ultimately, the decretial portion depends upon whether or not the findings of fact and conclusions of law are appropriate. I've looked at this, and I have several things. One, the procedure with regard to an appeal was something I was not familiar with, and I looked it up. And anyway, in anticipation of an appeal, I hadn't heard anything from the board or received anything, and I think the ordinance requires that notice be given, and there is a 30-day period after that notice had been given. Anyway, I was helped by Mr. Carnes, and he responded to that. But now I know that I think the 20th of August is, depending upon the date that you all send the notice out, if it is today, it would be the 20th of August. So what I did, I sat here and listened, as you did, with a presentation by Hunter DeFries, who stated that he had one conversation with Donovan Spence, whose mother owns the lot across the street, and that nothing had come of that. But my understanding, and I think I heard it accurately several times, that was that he would make contact. Jared, and I do not know his name, but I've met him, is with Atlas Stark and is a superior to Mr. DeFries. So I called Jared, I believe, on the 12th, and I said, I understood that Hunter was going to have a conversation with folks. I had not talked with Ms. Spence or any of her family about that, so I didn't know. I said, but nobody has contacted me. I was there. I heard that was going to be the case. Well, he kind of danced around, but ultimately he deferred to Hunter. So I called Hunter and I talked with him about it. The ultimate from him was, we don't think it's a problem. Well, that's really strange because it is the reason that you were presented with the application, spillover parking. And that if it did become a problem, he would involve the appropriate parties and the town. And my understanding from him was that he felt that it was more of a town problem. And my conversation was to him, if I have a problem here, I would like to know who I need to contact to deal with the problem. The end result is nothing was done. And my assessment is that once they felt comfortable that they had the variance, they didn't need to do anything else. So that is just basic information. But I want to call your attention to the finding of fact number 10. Start there. There is ample evidence that during the daytime there is going to be a conflict. And I will tell you, I've taken pictures and over the past week or so, there is a problem. And there will be a problem. You're going to have 4 restaurants during the daytime competing for all these parking spaces. That's a problem, and it won't go away. I don't know what number 13 means. I didn't know that there was a, the adjacent lot to the property. I did not understand, or if maybe I misunderstood, but I thought it was one tract and that there was no adjacent lot. I don't understand that. Number 15, Mr. DeFees stated that his company had attempted to locate additional off-site parking areas for the proposed restaurant without success. Now, an attempt is something that I take to mean an act in good faith. And all you have heard is that there was one conversation with Donovan Spence, and I think Donovan stated that he put it to him, what do you propose to do? What would you pay? What would you offer for use of our lot? That's not an attempt. The other thing, and this is where I really have a significant problem and would say that there is no evidence to support number 16. The non-overlapping hours of operation of tenants in the structure together with on-street parking and other unrestricted downtown private lots could be expected to mitigate the demand for parking from the building at periods of time when the demand for the parking would be otherwise high. And I specifically said that if that should occur and it's a problem for me, that'll be taken care of. It imposes on me what I feel is an undue burden. And I think from what you heard from Ms. Whitley and her brother, the children of Ms. Spence, that there was no desire to accommodate, and quite the contrary, that they were being imposed upon, and this assumption is not supported by any evidence. So I look at these different criteria here, and I think that most of them are the conclusions of law, and I think most of them are subject to challenge. And one in particular, the requested variance is considered consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. Now, you got Clayton Food Town, which was originally there. It fought Food Town to maintain its name. We fought a lawsuit, and they won the right to do that. They have been there, and they have created commercial value along Lombard Street. There were 5 dwellings there, which they took and used as a part of the development here. They've been a core business for this town for at least 40-some years. And this is not substantial justice. What it does, and you think about it, and I think about, okay, what am I gonna do? You've got to get a towing company. You've got to get a towing company. You've got to put a sign, or you can put chains up. And that imposes on me something. I have been here for almost 50 years, and I've seen it when there was nothing downtown, and thank goodness there is, but this is more than it can stand, and it does not do justice to those of us who have been here, and I want to see it. I want to see it, but there's enough. It is a problem. What's going to happen, and this, in my opinion, is subject to some significant challenges, and that before doing anything, somebody should suggest or require that they make good faith efforts to secure off-street parking at other lots, which has not been done. Thank you. I don't need to make part, and I won't wear you out, and I appreciate the opportunity to be heard.
Thank you, Mr. Tu. Whereas at this point, action by the board on these findings of fact, we are obviously reviewing these. Do we need to take any kind of action at this point?
Mr. Chairman, the hearing, of course, was closed. The decision of the board was to grant the variance. The 4 statutory standards concerning hardship, not self-imposed, and the special code requirement concerning, or code standard concerning, reasonable efforts being made to locate additional parking. Those are the required findings in the case. It is customary for there to be a set of findings that are case-specific and to some degree fact-specific related to the evidence in the case. That's what I've tried to do, is to prepare a page and a half of findings for you. If there are questions from the commission concerning, from the board concerning that, obviously that type of discussion would be appropriate. I would remind the board that the standard of review of the board's decision, including the findings, conclusion, and order, that comprise the decision is whether there is sufficient competent evidence in the record to support the decision. It's not that a reviewing court would necessarily agree with the decision. It is not that there was evidence contra to the board's determination, that there was evidence on the other side of the issues involved, but just simply that there was some reasonable evidence in the record to support your decision. What I have attempted to do is to draft for your consideration a set of findings that set forth, after my review of the video of this hearing, findings which represent some sufficient evidence to show that the code standards have been met and that your action granting the variance is defensible. And that is what you have before you. If the board's so inclined, I think it'd be appropriate to move to approve the minutes, including the findings and conclusions that are comprising a part of the minute. And of course, you would be asked to sign the order. So that's a review of where we are. I mean, with all respect to Mr. Chu, the hearing was closed. I understand he may take issue with some of the particular findings or how you weighed the evidence in the case. But based on what happened at the conclusion of the hearing, I've attempted to give you findings and conclusions that show some evidence and support your decision, and it would be appropriate to approve that if you're so inclined.
So if the board chose to tonight, and feels comfortable, we could take a vote to approve these findings of fact as written.
Yes, Mr. Chairman.
Okay. What's the pleasure of the board?
Mr. Chairman, just as a, being a little detail-oriented here for a moment, number 4, that is Atlas Stark versus Atlas Star in terms of a correction. And number 15, typo, locate additional offsite versus located.
Right, got it. Any other comments on the findings of fact that you have before you?
So if we were to make a motion, it would just be if those changes that Mr. Perricone pointed out.
I think so.
Based on the information from our town attorney, I'd like to make a motion to approve the findings of fact and the minutes from the last Board of Adjustment meeting.
I second it.
Okay, we have a motion and a second, and I assume that includes Mr. Perricone's revisions.
Mr. Perricone.
Motion and a second to approve the findings of fact as presented with the revisions that Mr. Perricone has brought forward. All those in favor say aye.
Aye.
Opposed? Motion carries.
Mr. Sims.
Yeah, Mr. Sims. Thank you, Board. That moves us down to the amendment to our agenda that we spoke about earlier, our rules of procedures. If you recall, back in June, the draft rules of procedures were circulated, and we basically took those under advisement last meeting in June, and with the understanding that we would take a month to review those and then come back at this July meeting and discuss any comments or revisions that we saw necessary, and potentially may adopt those. Raz, do you have any comments on the rules that we need to be aware of?
No, sir. It might be, this may not come within the rules of procedure as they're presently written, but if you're discussing your practices and your procedures, it might be, I'd be interested to know if the board and staff are interested in pursuing this method for developing findings and conclusions in your cases, or if you'd like to move in a different direction. My experience had been that some of the very smallest towns just have the 4 summary standards, better their findings in the cases. I'm working on with 2 or 3 other towns BOAs, and I have found that generally speaking, the attorneys for the boards prepare findings, as I've attempted to do in this particular case that you just heard. Some towns have their attorney develop very extensive findings with respect to each decision made, and it might be interesting to hear the planning staff's experience, just to know if this is enough, not enough, just right, what their experience has been with the other towns that they've been involved with concerning preparing findings on these cases. That's just an issue you might want to add to the mix. That's all I'm saying.
Okay, yeah, absolutely. And the rules that you presented, does that support what you just outlined, the attorney providing the findings of fact to the board?
I don't think we talk about.
I was just looking for that.
I don't think I addressed that, because frankly, that falls in the to be determined category.
Okay, I understand. I personally like the attorney providing us with the draft findings of fact. If that's something the board agrees with, I think we should ask the attorney to include that.
I concur with and what we have this go around. Start with that. Obviously, if things evolve, we can ask for more or less going forward. But,
Thanks, sir.
You were asking for a basis of comparison, right?
I just didn't know if Mr. Hales particularly had experience with some of the larger municipalities he's worked with concerning preparing findings and conclusions.
I think it's
in these
valuable
cases.
to listen to that.
We hadn't had this conversation. All this really came together the last couple of days.
Yeah, absolutely.
I generally support the sentiment that the chair expressed there. Variances can be totally different. I think the 2 you've seen in the last month are evidence of that. The former one was about parking and what's going on in a busy downtown area, and this one is very technical about different agencies that are reviewing and approving disturbing sensitive environmental lands. I think staff certainly doesn't have a problem on adding substance to a framework that attorney recommends on each case. But there, I think, are many times when we're not going to have a lot to add. I don't believe we've made many changes on the draft Raz sent over on this one. But I think we need to be engaged. But I think making sure there's a good defensible framework we're building on is a prudent thing as well.
Okay. Thank you.
Just wanted to add in, I regret, staff is also, like you, adjusting to the new regimen and monthly schedule and all that, and I regret that weren't able this month. We had number of people out, able to have a review right after the applications came in before the agenda goes out, so we can next month try and have a more complete package coming out. The fact that we had the city engineer testifying and we didn't have written materials from him, and we didn't have our findings as soon as we could have, and some amendments in the staff report as well. But I think you all getting your feet on the ground, approving the findings this time, that's more of a framework for us going forward, and I hope we'll give you a more predictable package that's not changing or having too many add-ons. At least do our best on that.
All right. Well, I would say to that, Dick, that I really, for one, appreciate you having the town engineer here tonight. I think his testimony was invaluable. So kudos for that. So I think I'm hearing that we would definitely want to include the attorney drafting up the findings of fact to be presented to the board in our procedures as a regular item in the procedures. Any other items that you'd like to talk about? Any comments? Any changes?
On the procedures? Oh, somebody's.
I'm sorry.
Is it okay if I ask a question on the process?
Sure.
Just for clarification on those findings coming back to the board for the review like you did this evening, does that affect the timeline from the applicant's standpoint for final approval and allowing us to move forward with construction drawing review and things and investments and things of that nature? Is that decision going to affect our timelines? Or is that decision effective the date you make that?
Excellent question. Thank you. I actually was going to ask later, and it's perfect timing now. I'm assuming this plays into the appeal period, Raz, so I'm interested to hear what you say.
The subject to staff's input on this question, the way this is handled in the city of Raleigh, that's the practice I'm familiar with, a quasi-judicial board renders its decision, either the Board of Adjustment or Raleigh's case, Historic Preservation Commission. They give a notice of decision that is transmitted to the various inspections staff members, and that serves to free up further permits. The applicant is not being held up at that point. And however, the decision itself is final at the next regular meeting when the official findings, conclusions, and order are adopted. But the notice of the granting of the variance goes out so that you're not held up as far as other permits go. That's the way, that's been my experience, if that would be suitable with the Clayton staff.
What are the ramifications of an appeal and, in particular, a successful appeal?
Well, interestingly enough, if there is an appeal, well, let me back up. If there is a denial and there is an appeal, there's an automatic stay per the statute. There is no provision for preventing an appellant to upset the apple cart whenever a decision is made to grant the variance. You all may be familiar with the Raleigh Historic District Commission's decision where they approved a house in Oakwood, and during the notice of appeal period, the inspections department granted the permit because the certificate of historic appropriateness was approved by the Historic Commission. The owner started building his house, and about 30 days following the hearing, an appeal was filed, and everything was in turmoil. And I would say to you, there may be some risk if you proceed, particularly if you proceed with construction, if that's possible, and an appeal is subsequently filed, and the case conceivably reversed. But as far as the property owner's decision is concerned, once this decision is made this evening, that normally would provide notice that the green light has been given for further permitting.
So Razzie, for just further clarification, as we approve this variance tonight,
yes, sir.
We're not waiting on the RCA impacts, we're not waiting on the town of Clayton soil erosions, we're not waiting on final designs of subject to prove before we allow them to move forward.
Well, my understanding of that is that the granting of the variance is just simply the variance from the zoning requirement, the RCA zoning restriction. Every other regulation at the local, state, or federal level is still effective, and all the other regulatory hoops have to be gone through. So this just relates to varying this one zoning regulation, this one zoning ordinance provision.
Okay, that much, I did understand that, okay.
So, Raz, is there, on the appeal, going back to the city of Raleigh, they have a 30-day appeal process. Is there a statutory timeline, once we approve it, that you have 30 days to appeal Or is there no standard appeal period?
No, it is 30 days. It is 30 days from the, I think it's the mailing of a copy of the official finding to the parties that have appeared. It's either 30 days or 30 days plus 3,
Gotcha, very
the
good.
notice period.
Okay.
But that's generally the timeline that you're looking at.
Very good.
And the date of the order would be, of course, the date you signed, which would be probably this evening.
Mr. Asbury, so you're saying that for the lot variance, which is affecting us, that the back findings are supposed to be mailed to us, is that what you're saying? I'm confused.
Parties withstanding that have given notice in this case, I know that, and I'd have to look at the record in the case, and I'm sure staff would be happy to send you a copy of the notice or provide it to you or a copy of the order, or give it to you this evening. But yes, the official decision, not just their motion that was approved 30 days ago.
And we have 30 days before the time I received that?
Correct.
I
Correct.
haven't received it yet.
Correct. It hasn't been adopted yet officially, but that's
So it's adopted officially today, y'all all approved it?
presumably it'll be signed today or shortly thereafter, but that starts the appeal clock running.
All right, thank you. It's not this copy, it's a signature copy. When it is signed, when is that typically done? What now?
It will be short.
Short. Yeah. Short being tonight, tomorrow, 2 weeks.
Possibly, yes.
Couple of days.
It's at 30 plus.
Plus there's a couple of days in there. And then it is mailed out to the people. Is that what you're saying? Okay.
Yeah, that's generally the timeline. Obviously, if you or any others are contemplating filing an appeal, you should rely on your own attorney to advise you about any procedural requirements and not necessarily what we're laying out tonight, because your attorney would need to represent you in that respect as well.
Thank you. Okay, any other discussion on the rules of procedure?
Just one, Mr. Chairman, section Roman numeral 8A, scheduling. Not a big deal, but personal concern with reasonable time. Since we know this board meets on a regular scheduled basis, it seems like it would be better to define that more specifically than reasonable, because my understanding of reasonable and my 7-year-old granddaughter's understanding of reasonable can be completely different, as a small example.
Understood. Does the town attorney have a definition for reasonable?
These are intended to be your rules, so I would say that's just a call that you would need to make. I would say from experience, there are sometimes perils in having your rules set out what I call a shot clock on scheduling a hearing. Typically, you would offer guidance, say such to be normally within 30 days or something like that, but good gosh, things happen, and sometimes there are delays that are unforeseen.
Yeah.
And I know Raleigh's historic crowd has to act within 90 days of receipt, and things happen, and there are all kinds of questions that came up about, if we don't get this scheduled and decided by such and such a date, does that mean the application is automatically approved?
Right.
So just be cautious. I'd suggest you might want to consider just a guideline or an operating goal here, but not put a shot clock on yourself.
Yes, you're right. And I think my experience has been it is very dependent on staff to receive a complete application, be able to process it and get it on the next available. It's got to be reviewed. There's a lot that's got to go in up front before it can be scheduled at the next meeting, and we only meet once a month, so 30 days seems a little soon for me. Do you have any idea? I mean, if we're trying to put a time on this, reasonable. Yeah, I mean, there's just so much that goes in up front on your end that
Right.
30 days is a short amount of time. So,
Yeah, I mean, I tend to look at it as 3 stages. One is something comes in, we only receive on the first of the month, first business day of the month. BOA meeting is about 6 weeks later. So that's kind of set, unless there's some changes, something that delays it going to the board. And then, once you have it, we have this 30-day period to the next meeting. We've been going through on adopting the findings and decision. And then that starts a 30-day period to see if someone's going to appeal. If they do appeal, the town gets a notice from the courts saying you have 30 days to produce a verbatim transcript of what occurred. So those are sort of the maximum steps you can get into, and then the scheduling and the holding of the court proceedings follow. Now, as I understand it, it's certiorari only, so all they review in the court proceedings is the record, so there's not other rounds of testimony and cross-examination or anything like that. So I don't know, Raz, what that typically translates into about timeline between filing of the court appeal, receiving verbatim transcript, and then scheduling a response from the courts.
I think Section 8A just relates to the time period for the staff to calendar the hearing after the application comes in. The appeals process after a final order, that is all covered by the rules of procedure and general statutes. So that's not anything that you all can modify. You may want to just put something like, such is typically expected to be 60 days or less, or something like that, just as putting a benchmark there without having it. Because if you say such to be no later than 60 days following receipt, then the question is, well, what happens if you don't meet that deadline?
right.
So, I mean, just to put a layer of practicality on this, right? So the reasonable man argument is one where would a reasonable person think what you did was appropriate, right?
Right.
So if it took 6 to 8 months to schedule a hearing, I don't think that would be reasonable, and most people would agree with that, right? So I don't really, I get your point about reasonableness. I don't like it in contracts, but in this case, it's not a contract. We're talking about procedures. I think that it's appropriate, because reasonable would be, like Raz said, 30 to 60 days. Unreasonable would be somebody's parked on it and not moving with it, right?
Just one other comment, and again, I do understand the reasonable man argument. The other part of this is that it's the time frame is based on the filing of the application. I think the deadline or the count should begin with the acceptance as complete, because I think that's the relevant point in time, because if you have 5 requests to get to a complete application, you can burn through a lot of time while you're waiting on the applicant. So, I should have mentioned that earlier, but I was thinking that from that point, setting a time frame, not from the filing, because the filing means nothing if it's not complete.
That's one reason why I intentionally put completed there before application, because that's been the way that Raleigh has applied. It does have a shot clock on applications, and so when that shot clock starts running is a critical determination, and so they say unequivocally completed with all required attachments in a form approved by the planning staff. It has everything has to be in order before the application is considered to be received.
So back on time, what's thoughts? Do we want to put a time?
I've articulated my thoughts. I'd like to hear from everyone else.
Well, I think, Dick, a lot of it falls back on staff, and looking at the first of the month's the middle. Obviously, we meet on the third Wednesday, so we obviously could not meet then, so another 30 days there, so that, we're into the 45-day category already. So
I'll throw out the straw man, 60 days from it being deemed complete and some degree of specificity on what is complete.
Right.
As an alternative.
I would, you guys, that sounds reasonable?
Well, 60 days now, if you don't have a board meeting within that 60 days, that could be problematic, right? If you're it's just about scheduling a hearing, right? So maybe if you're going to put a time limit on, I would say the next board meeting after 60 days or something like that. So you don't hit something where you're like 66 or 70 days and then you're in trouble.
You don't have a quorum.
Correct. But you just laid out a timeline that's 45 days. You think that's?
No, 60 days from when the application is deemed complete.
Yeah. I guess that works, yeah. You should capture it within a cycle or two.
Yeah, and I think, we're talking about scheduling, we don't have a quorum, it was still scheduled.
Right.
We're making best effort.
Quorum is another matter altogether.
That's another, right, exactly.
Okay, that's where I'm.
Yeah, is that kind of good?
Yeah, thanks.
Okay. 60 days. Any other comments?
Yeah, I'm going to have one, but there's a couple things. We ran into a little bit of spot of trouble at the beginning with who can make motions, who can vote, right? And when we're looking at Section 3 membership appointment, it declares that the board consists of 5 regular members and 2 alternate members, right? So now that's what's considered the board by this definition. I think we need to make a distinction about the voting, and I think I may have missed it. Right, voting required, all board members, including chair, shall be entitled to vote on matters before the board. This whole section, I just want to make sure that we're clear that the alternates are non-voting members unless required, unless there's an absence from the board, from a regular voting member, right? I just want to make sure that we're clear with that. And if it is, that's fine. Again.
No, that's a good point, Tom. Very good.
So, go ahead.
That's generally the function of the alternate members, to be on standby, and if there is a recusal or an absence or a vacancy, the alternate member can assume a voting position at the table. Y'all may recall that the council passed the ordinance saying that ETJ members have the right, just the same rights as the inside the corporate limit members to vote on all matters. So the ETJ and corporate residency distinction does not matter.
So we're relying on that ordinance.
That certainly would trump.
Okay.
And I tried to draft the rules of procedure specifically to conform to what the UDC states in your case.
That's fine. If we're relying on the modified language, then I think then it should be covered. Now, the second thing I have on is related, as to who can call a motion to the board, right? That's not clear. The way it's written, again, I guess if I just took the plain language of this, any board member, whether they be a regular member or an alternate, can call for a motion, which seems a little odd because we can't vote if you're an alternate.
If I may, my thinking on that is, and it's the reason why I was a little bit, I was questioning at the previous meeting who will constitute the 5 participating members at the hearing last month. It should be very clear who will be the 5 members that are seated for the conduct of business, and those members will make motions, deliberate, offer comments, and vote. And the alternates will be standing by.
Right.
And the standby situation is sometimes necessary because you have recusals, and it gives you problems with a quorum and getting the required majority for vote requirements. So those are the two things that can happen so far as the alternates are concerned. The alternates don't necessarily have to be here if they don't choose to, and if you don't anticipate any recusals, and if everybody reports they're going to be here, and if there are no vacancies. But again, the members that are seated and ready to go, that should be clear. And if an alternate is standing in for the conduct of business, that probably ought to be shown in the record as well.
Should that just be added as a standard agenda item right at the start of the meeting to make sure it's ticked off every time?
That's not a bad idea, yeah.
Just going to add to that alternates can be seated unexpectedly sometimes. I've seen board meetings where someone says, my son's graduating from high school at 8 o'clock and I'm leaving this room at 8 o'clock. You know about that in advance so you can sort of prepare for it. I've had several instances where someone got sick during the meeting and left. Partly one was having to do with sexually oriented businesses, and they got physically ill from some of the discussion, and other time it was just somebody felt bad when they got there and felt worse during the meeting and left, and that was totally unpredictable ahead of time. So the value of having the alternates there listening to all the testimony is invaluable. Had one where we had a 12-hour Board of Adjustment meeting, and someone got sick right near the end, and the fact that the alternate was there the whole time, listened to all the testimony, kept us from having to invalidate the entire 12-hour hearing. So it can come in many shapes and forms, and sometimes you know about it ahead of time. If the chair lived across the street from a variance request and knew it weeks ahead of time, you could let everyone know, say, we're going to need an alternate seated on this one case, and other times it comes up out of the blue.
Yeah, I totally agree with that. I started the planning board in another life as an alternate, and I just felt that was expected to be here, and because you never know what's going to happen. So I would encourage our alternates to be here, ready to go, if everybody else feels that way.
Can I ask a question on that, Chair?
Absolutely.
So I just think it need to be known that though the alternate should be able to ask questions in case something, somebody goes out, then, we don't have to rehash everything, and they're able to ask questions.
I agree. Any problem with that?
I think that's fine. It's in the discretion of the chair and the board concerning gathering as much information as possible.
Yep.
It's not part of the deliberation, it's not part of the decision-making process per se, so that I don't think the alternate should participate in the deliberation. But I think a question, that sounds entirely reasonable to me.
Yep. Good point, Mark.
So,
Yep.
so the agenda will now include identification of who's who at the start,
Yes.
so that everyone, both board and members, staff and members of the audience.
Absolutely. Assuming you remind me to do that, I will be happy to do that. Mr. Raspberry and I have talked about that earlier, so
You've
yes.
got a number of people that will hopefully remind you, not just me.
Absolutely, absolutely. We're just across the window together.
So somebody made a comment about adding the routing. With the notice decision that the young lady brought up, and the routing is a very valid point, just for expediency and certainty for folks who come here. Is that something that's appropriate to add to this rules of procedure?
I think when you say routing, you mean sending a copy of the final decision. Routing, is that what you're speaking of?
Correct.
Okay. the statutes require a copy to be sent to the applicant and all of those who have standing in the case. I would say it's customary for anyone who has appeared in the case to also be sent a copy if we have their names and address, and particularly if they request to have a copy sent to them of the final decision.
Clarification of what my question actually is. We made a decision, or the board made a decision, I should say, today on the subdivision, and the question that was posed to the board was, can we start, right? Or
yes.
What certainty, level of certainty? And you had mentioned that Raleigh, as an example, would route that decision, the notice of decision, to the planning department so that should they choose to take the risk on the design costs, that they could proceed with that while the appeal period ran or immediately, right? So that's the question I'm asking.
Sure. You know, my thought would be, it'd be entirely appropriate for some written confirmation to be sent, notice of the decision to be sent to the applicant. That seems fairly obvious and entirely appropriate to me. I'm not familiar with the paperwork.
Sure, I'm thinking on the
as it's been handled in Raleigh, but I'm pretty sure that's what staff does.
And maybe that's more appropriate for staff to work with, just as an.
I think so. I think so.
Okay.
Yep.
So the only other things I had, I just want to, you know, I'm going to slide this over here to you. There's a punctuation issue right here. On page 5, 7.
Right. So following in paragraph 7, line 4, sentence begin, in order to be heard, capital I, begins a new sentence, in order to be heard at the next regularly scheduled meeting. The completed application, together with all necessary plans, exhibits, and filing fees shall be provided to the service at least 20, right. So that's really what a completed application is. It elaborates on when the clock starts to run for scheduling hearing.
Yep. Okay. That's it. That's all I got.
Okay.
Thank you.
All right. Coming up on 8 o'clock, and I would say, unless, if everyone agrees that maybe we give Raz some time to incorporate these changes and maybe come back to us in our August meeting with a clean draft, and we can look at it again and possibly adopt this. Sound good?
Sounds good.
All right. With that, we have one item left, and that would be for adjournment. I'll entertain a motion. Do I hear a second? I think I heard a second. All those in favor say aye.
While I'm walking out.
Opposed? Nobody. Everybody's seen them gone. Motion.